Awesome. Hello, everyone. Good afternoon, good evening. My name is Tahil Sharma. My pronouns are he and they. I'm the program director at the Interfaith Center at Miami University. I'm also wearing my other hat today as the Faith Work Director at the National LGBTQ Task Force. And the reason why I'm getting the chance to wear both hats today is because this is the second event of our series on same-sex marriage. I'm really excited to be able to have this space available to get to know folks from the Miami University community and from other places around the country who get to take part and be a part of this conversation to learn about this conversation on same-sex marriage. It's great to see familiar faces, and it's great to know that other folks are joining in. The reason why we started this conversation last year really had a lot to do with our opportunities to be able to engage the interfaith contexts and how they impact our understanding of the LGBTQ community at large. One of the ways that we knew that this conversation was deeply intersectional was understanding the roles that faith, religion, and spirituality played in being able to protect the sacred right of marriage in its traditional sense to becoming a more inclusive space for LGBTQ people to participate in the same idea of union. We were able to host in-person events for Coming Out Day on campus, to being able to host events with partner organizations like Rainbow Railroad, as well as having local community members who got to contribute to this conversation from their perspective on what same-sex marriage meant to them. But today we have a special opportunity in getting to do a bit of the deeper dive that we need to be able to learn about the idea of what same-sex marriage has been about in a legal context. What we see as a lot of the ongoing challenges with being able to protect that right for same-sex couples, and what the future looks like for marriage for LGBTQ people as a more inclusive opportunity for union. So I am very excited to be able to introduce a colleague and a friend who is speaking today on behalf of the National LGBTQ Task Force. My dear friend Kenya Imani Whitaker, whose pronouns are she, her, hers, who serves as the Government Affairs Associate at the task force. While I drop her bio in the chat, I will also be reading it out for the recording. Um, Kenya Imani Whitaker, she, her, hers, is a movement lawyer and government affairs associate at the National LGBTQ Task Force. Kenya's work focuses on advancing systemic change through community and organizational partnerships and policy enhancement. Growing up in Prince George's County in Maryland, Kenya's deep roots in the DMV area have shaped her commitment to justice and community empowerment. Kenya's legal experience spans a broad range of activities, from representing housing cooperatives and assisting nonprofit startups to advocating for parole for elderly clients. Kenya's dedication as a movement lawyer is evident in her work to create policies that support gender justice and improve the safety and well-being of Black, Brown, and LGBTQ plus communities. I find it really exciting to actually have Kenya here today as someone who I've gotten to know over the past year or so with our work together at the task force. And it's a really amazing opportunity to have her be here present today to actually speak through her expertise, through her learning, and to be able to help educate you all. So, without further ado, Kenya, I'll pass it right over to you.
Hi, thank you so much for that lovely introduction, Tahil, and hello to everyone here. Thank you so much for joining. I am excited to dive in to talk about the sake of same sex marriages and the future of same sex marriages. So, again, thanks for taking the time out to listen to this presentation, and I hope you enjoy it. All right, so to begin, I'm going to go over some questions that I will seek to address today, maybe not answer in its entirely or fully, but these are three questions that I would like to address. So the first one is, why is Obergefell and other precedent important? And by precedent, I mean case law that came before Obergefell, which we will dive in the later slides. Number two, what does it mean if the Supreme Court decides to take up the challenge to Obergefell? And three, what can people do to protect their same sex marriage, relationship, partnership? So I wanted to start off with present day and then go into the timeline on how we even got to this point. So just recently, the Supreme Court was asked to review the 2015 decision of Obergefell v. Hodges and figure out if it was decided erroneously. The person who brought the petition, which is formally known as a writ of certiorari, was Kim Davis, and she brought this petition in July 2025. Kim Davis was the former Kentucky County Clerk who denied and refused to provide marriage licenses to same-sex couples in 2015, and she did so on religious grounds. And this is a picture of her right there. So, continuing, like I said, a writ of certiorari or a writ of cert is a formal order issued by a higher court to review the decisions of a lower court. So, it is a order issued by the Supreme Court to review the decisions of a lower court, usually a lower federal court. But great news is that on November 10th, which wasn't too long ago, the Supreme Court denied Davis's challenge to Obergefell. So there was some victory there. And usually, when the Supreme Court denies to review a decision, they don't have to give any reason to do so. So, like I said, I want to go back in time to talk about the case law that build upon the monumental cases such as US v. Windsor and Obergefell. So, how did we get here? Here's a timeline. Starting with Bowers v. Hardwick. This was a 1986 case that said that the 14th Amendment does not prevent a state from criminalizing private sexual conduct involving same-sex couples. This case took place in Georgia, and essentially it just said that there is no constitutional protection for acts of sodomy. So the court really looked at the fundamental right at question very narrowly, and they thought that the fundamental right that was being asked is whether or not individuals have the right to engage in sodomy, which, as we know, was not the question that was really being presented. The next case is Romer v. Evans, which was decided in 1996. So 10 years later, you have a Colorado amendment that denied legal protections to individuals based on their sexual orientation. And the thing about this case that's really interesting is that it was actually ruled unconstitutional. So while we have Bowers v. Hardwick, which talks about the act of sodomy not being constitutionally protected, you have 10 years down the road a Colorado amendment that's ruled unconstitutional because it's denying legal protections to individuals based on their sexual orientation. And so the same year, you have Defense of Marriage Act. So Romer v. Evans is in May, Defense of Marriage Act, or DOMA for short, is in September, and it banned federal recognition of same-sex marriage. The next slide would dive a bit deeper into the Defense of Marriage Act, but for now, this is the overview of it. And then finally, you have Lawrence v. Texas, which is a 2003 case which talks about adults having the right to private sexual intimacy regardless of sexual orientation, and it overturned the infamous Bowers v. Hardwick case. So as you can see, the trajectory of LGBTQ plus rights through case law and through policy, Bowers v. Hardwick, again, looked at the fundamental right at question very narrowly, whereas Lawrence v. Texas took a more broad approach. The justices saw like, okay, it's not about engaging in sodomy only. It's about privacy. It's about intimate relationships. It's about the government not having overreach in these intimate consensual relationships. So you can see how over time, the courts decided to read the cases at hand, the facts at hand, and the rights that were being brought forth at hand. And I'm going to stop there. Are there any questions?
Kenya, we're gonna have folks sort of hold their questions towards the end.
Okay. Okay.
So you can just keep going with your flow. All good.
Okay, cool. Cool beans. Okay, so like I said, diving into Defense of Marriage Act or DOMA. So DOMA was actually I would say initiated due to Hawaii's case by Bear v. Mike, which was initiated in 1990 to recognize same-sex marriage in the case. And with DOMA, you have legislators who are fearful that if Hawaii agrees with the petitioners to grant same-sex marriage, then it would have to be recognized federally. And so they fear that if they recognize same-sex marriage, then they would have to also recognize polygamous relationships, um, incest relationships, etc. So it's a slippery slope idea. It's very homophobic, very outdated. The root of why the Defense of Marriage Act was even drafted and eventually passed. So the law passed in 1996, like I mentioned, September, and it was passed by the 104th Congress, and it was signed into law by President Bill Clinton. The definition of marriage under this act was only a legal union between one woman and one man as husband and wife. And again, the underlying purpose of the act was to disregard any recognition of same-sex marriages, relationships, and because they believe that the sole purpose of a marriage is to procreate, and because same-sex couples cannot procreate, they felt as if that this was the right way. So going to 2003, Massachusetts becomes the first state to recognize same-sex marriages, and also 2003 was the Lawrence v. Texas decision. So 10 years after Lawrence v. Texas, and after Massachusetts becomes the first state to recognize same-sex marriages and unions, you have U.S. v. Windsor, which is a 5-4 decision. A little facts about the case. So Edith Windsor was a widow and sole executor of the estate of her late spouse, who died in 2009. They married in Toronto, Canada in 2007, and it was recognized by New York state law. Her partner that passed away left her estate to Edith. And because the marriage was not recognized by federal law, the government imposed a $363,000 tax. So the question before the court in this case was, does the Defense of Marriage Act, which defines marriage as one woman and one man, deprive same-sex couples who are legally married under state laws, and essentially is it unconstitutional under the Equal Protection Clause? Yes. Short answer is yes. Y'all already know this, but I think it's still good to go over. Essentially, the court said that same-sex marriages should reap the same federal marriage benefits as opposite-sex marriages. And the impact of this case specifically was it expanded the implied fundamental rights as it relates to members of the LGBTQ plus community, and it included same-sex marriages for the purpose of federal marriage benefits, as well as pretty much overturning a section of the Defense of Marriage Act. So you have Obergefell v. Hodges, which comes 2 years later. Again, another 5-4 decision. The facts of this case is Obergefell sued, saying he was unable to put his name on his late husband's death certificate, along with other plaintiffs from Ohio, Michigan, Kentucky, and Tennessee. And the question before the court is whether the 14th Amendment's due process and equal protection clauses require states to license and recognize same-sex marriages on the same terms and conditions as opposite-sex marriages. So similar to Windsor, although that case was focusing on federal benefits that marriages are able to seek, this case focusing on licensing and recognizing marriages federally under the full faith and credit clause. So the holding was, yes, the right to marry is a fundamental right under the 14th Amendment, and the inability for same-sex couples to marry violates the Equal Protection Clause and due process clauses. And case law that they used to support that was Loving v. Virginia, which was a case that said that interracial couples do have a right to marry. And so the impact of this case specifically was that it made same-sex marriages legal in all 50 states, and states must also recognize same-sex marriages granted by other states. It also overruled or made defunct Section 2 of DOMA. So while US v. Windsor, I believe it was Section 3 of DOMA that was defunct, Obergefell made Section 2 defunct, and pretty much DOMA is overruled. So I wanted to go to the Respect for Marriage Act and why that is so important and pivotal to this conversation and how it relates to abortion rights. So you have the Dobbs decision, which overruled Roe v. Wade and Planned Parenthood v. Casey. And that in itself was a blow to reproductive rights and the breadth of case law that enshrined those rights. So now you have people worried because they're like, okay, if they can overturn decades of case law with something that was supposed to be constitutionally protected, they could do the same with same-sex marriage. And it is Clarence Thomas's concurrence in Dobbs, which really gives people fear because he directly points to Obergefell in revisiting that case because he argues that it's not protected by the 14th Amendment. So you have Respect for Marriage Act, which was introduced less than a month after Dobbs was decided. It passed the House the next day, July 19th. It passed the Senate in November of that year, and then it became effective on December 13th, 2022, after President Biden signed it into law. And the purpose of the Respect for Marriage Act is to keep the fundamental right of marriage as the law of the land if Obergefell is overruled. And again, it just adds that extra protection of repealing DOMA and nationally redefining marriage with no specific mention on gender. So the future of same-sex marriage, I started off the presentation with the Kim Davis petition to review Obergefell and how the Supreme Court denied it. So we should rejoice in that. That is victorious because there was no reason for her to even want to do that petition. But anyway, the point I'm making is we are safe for now. However, we don't want to get comfortable. And the reason why I say we don't want to get comfortable is because you have the Texas State Supreme Court back in October of this year, which allowed judges to deny wedding ceremonies for same-sex marriages on religious grounds. So although it's not denying marriage licenses per se, still the idea of denying wedding ceremonies and them being able to do so on religious grounds, to me, is them trying to chip away at same-sex marriage protections. And then I listed these other states because these are red states with legislators who are homophobic and against same-sex marriage. And these are also states that have constitutions that do not legalize same-sex marriage. And so if Obergefell were to be attacked again and the Supreme Court decided to review it and, let's say, overturned it, then essentially these would be the states or some of the states that would deny same-sex marriage protections. But I want to end on a good note and say like how to protect same-sex marriages or ways in which you can protect same-sex marriages. So estate planning is essential with advanced directives. You can store an official copy of all legal documents, including marriage certificates, adoption, or parentage judgments in a safe place, and keep a scanned copy handy on smartphones And then for children and family planning, you can protect children with adoption or parentage judgments from the court. And essentially, all non biological parents are encouraged to get an adoption, parentage order, or other court judgment, recognizing that they are legal parents, even if they are married, and even if they are listed as a parent on their child's birth certificate. So, overall, we went over the present day of same sex marriage and how, although there wasn't a wanting to be an attack on Obergefell, that was denied by the Supreme Court early November. We went over the breadth of case law that got us to where we are and the monumental Obergefell protection. We talked about DOMA, or the Defense of Marriage Act. We talked about the Respect for Marriage Act. We talked about the future of same-sex marriages and how to protect same-sex marriages. So I hope you enjoyed this presentation and I hope it was informative. Thank you.
Kenya, thank you so much for providing so much of that context. I think I learned quite a bit, and I know that many others on this call probably did as well, because a lot of folks like to think that when they focus on the bigger cases like Defense of Marriage Act or Respect for Marriage Act or the Obergefell case, that that's kind of the limitations of how the history of same-sex marriage works in the United States. And sure enough, it goes much deeper than that. There's so many different cases that overlap and can impact the way people can interpret and fight for or against the case of same-sex marriage. So I really appreciate you providing that perspective. Um, Before we get into some time for question and answers, I first want to be able to actually share some important perspectives. Now, as we think about the conversation of the future of same-sex marriage, it is also really important to consider the role of faith communities in this work. One of the things that we know constantly comes up as a counterpoint to same-sex marriage is the protection of the institution of marriage through the lens of religion. And oftentimes that particular lens being a Christian lens. One of the very important things that we have to pay attention to is the role of religion, and particularly Christianity, in its ability to be interpreted and then used as a means to be able to work against the rights of LGBTQ plus people. This is not a part of something that's come out of nowhere. There are decades of this history through legal and political work, while also really demonstrating a lot of an emphasis on changes in social attitudes. But I think what's really important to pay attention to at this very moment are actually some key statistics that are being brought up and taken note of as we develop this conversation on same-sex marriage. Two major institutions that focus on research, particularly around American attitudes towards social identities and policy, are the Pew Research Center and PRRI, which is the Public Research and Religion Institute, if I remember correctly. They both have been working on some really key research on the changing values systems and ideas around themes of same-sex marriage, protecting trans communities, reproductive justice, and more. And what I've dropped are two articles from both of those institutions that get to talk about some of that work through the research that was released earlier this year, both by Pew Research and some of the research that was done in 2024 through PRRI's American Values Atlas. And what you'll actually be surprised to know is that almost every single religion that we can think of that has a presence in the United States has a shifting positive attitude towards same-sex marriage. And that sounds really surprising when we recognize it in the context of the political discourse and vitriol that comes from Congress and from state legislatures. It sounds like that there is so much pushback and that there's so much dissent towards the idea that there may be more voices against it than we think. But the research shows from both of these institutions that the general attitudes towards same-sex marriages and the protection of those unions is actually increasing over time. And that really says a lot to the discourse that's happening publicly from LGBTQ community members And a lot of this has to do with the realities of relationship building that occur. One key part that's impact some of these conversations, from conversations that I've had with different organizations and individuals, has solidly been that more people who get to actually know folks that are LGBTQ do have a tendency to change their attitudes, especially when they know if legislation or politics is going to impact their daily life. And what ends up happening is in a context conversation related to religion in particular, you actually do see those shift of attitudes happening there too. And a larger question that ends up happening is, well, if we know that these attitudes are changing, along with what Kenya had mentioned as like explicit examples of ways to be able to protect same-sex marriage, what should faith communities be doing right now? Well, many of us may actually not be strangers to a lot of the divisions and schisms that are taking place in Christian denominations and between political factions within faith traditions. It's very clear that the decision is not made, the consensus is not made that everyone agrees with same-sex marriage. And what it's resulting in is the formation of politically aligned faith communities that tend to have specific views about LGBTQ people as a singular example. And what we end up seeing as a part of that is growing divisiveness too between folks of those faith traditions that actually lead to new religious movements forming as we speak. The most recent example being of the United Methodist Church, that has now formed a division as the United Methodist Church and the Global Methodist Church. These divisions, unfortunately, may continue. But if we're to actually hold some real, candid conversations about the ways that we want to protect LGBTQ people and their sanctity and right to marriage, we really do have to think about the ways that those rights are enshrined legally and what those rights actually cover when it comes to talking about religious communities, one of the main institutions that actually does provide marriages. So it's important for you to think about the spaces that exist at this moment where people can actually have same-sex marriages performed. There are a great number of progressive churches um, that are Lutheran, Presbyterian, Episcopal, Methodist, and even entire denominations like the Metropolitan Community Church or MCC, who are actually dedicated to creating the space through their own open and affirming commitments. And for those of you that may not know of any open or affirming faith communities in the area, it's really just about a quick search and being able to see where you might have access to those opportunities. And sometimes it may also require an opportunity to engage more deeply in having those conversations with spaces that are considering becoming open and affirming. Many major denominational institutions now provide processes and certifications for becoming open and affirming that you can definitely check out and start to have those conversations with clergy folks to be able to make that happen. But just as we think about it for the context of marriage, as Kenya mentioned, there are also multiple layers to what happens when you actually are married in the United States. We are talking about property, we are talking about benefits, we are talking about beneficiaries, to inheritance. There are a lot of things that get impacted by the conversation that are not just the union itself. And it's really important to be able to have those kinds of conversations in spaces where they often don't happen. So being able to help with estate planning, being able to make sure that everyone has their legal documentations covered so that your marriage doesn't get challenged and therefore anything associated with it gets challenged. And just as importantly, this is a growing conversation about the politicized nature of how we engage in our daily lives. When your identities become politicized, it is really difficult to be able to, show up in a space where your identity doesn't become a partisan issue, especially for folks who identify as LGBTQIA+. So it's also really important to consider the role that faith communities should be playing right now in speaking up against the injustices made by elected officials or by communities who are choosing to dehumanize LGBTQ plus people. This at a time of a lot of vulnerability and a lot of fear. means that we have to have deeper, more intentional conversations that are authentic towards the experiences of LGBTQ plus people who struggle with the idea of associating with religious and spiritual people. Creating spaces to be able to engage in deeper dialogue are urgent. They are not just needed, they are urgent at this time to be able to build alliances and to be able to lean into the authenticity that helps us build solidarity with one another. So again, I want to be able to thank Kenya for providing some of that you know context and for us to be able to really think about how we could be showing up. I also want to take this as an opportunity to be able to thank Meera Rajput, who's on the call, as well as our colleague Bhaktawar Desai. Mira also works at the task force with us, doing state analysis work in policy. She is definitely a co-conspirator in making this series of events happen. And Becca Ji or Bhaktawar Desai is one of the board members at the Interfaith Center, who came to us, Mira and I particularly, to be able to think about how we can develop this series this year. So we want to be able to share that gratitude. But going from there, I want to open it up for questions and just sort of continuing the conversation. And I want to take the personal privilege to just actually ask Kenya and Mira if she would like a question. Um, how much do you actually see, religious language or religious like ideology come up when you are studying sort of the history of some of these cases that lead to challenging things like same-sex marriage?
So much, so much. Is this for me?
Yeah, it's for you or Mira.
I
That's
see it come up so much. I mean, even with the underlying motivations for the policies, like when you think about DOMA, like the reasons for it was like, okay, well, it's between the idea of marriage is between one woman and one man because the sole purpose of marriage is to procreate. That has religious undertones to it. You get what I mean? And even when you don't talk about like the LGBTQ plus cases, but the precedent that builds up to even the right to intimate relationships and privacy. Like when you think about Griswold v. Connecticut, they were trying to even invade opposite sex marriages and what they do in their bedroom, and the idea like, oh, well, because the main and sole purpose of a union is to procreate, you can't have access to birth control or you shouldn't use a it's just that whole undertone of women and men are only supposed to be together because that's what the Bible says or other religious texts, and because the main reason is to create children. So you see it come up a lot, even when you look at Bowers v. Harwick. The actual statute, the Georgia statute, didn't mention a gender, like the idea of like anti-sodomy. It did not mention a gender, but the way that it was enforced against same-sex people and same-sex relationships because of that religious ideology. Um, so yeah, you see it come up a lot in the the history that leads up to the cases, the facts of the cases, and the actual justices like who sit on these courts, especially at that time, like their religious background, their upbringing, what influences their analysis of the facts and how they decide the cases.
Thank you for that. And Mira, do you mind if I put you on the spot with sort of a similar question on what you've been seeing at the state level? Because
Go ahead. Yeah.
speaking about it in a national sense is informed by a lot of state-based cases. But clearly, sort of the partisan approach to some of these conversations obviously is impacting the way California might have a different conversation from Texas or Florida or New York or Colorado. So, how are you seeing that sort of come up in some of the analysis that you've been doing at the task force?
Yeah, no, Tyler, that's a really great question. So looking at states like Texas, who Kenya just mentioned that, now they can deny doing the religious ceremonies. This is the state that also passed a law requiring 10 commandments in schools. And so when you think about how religion plays a role in marriage equality, it's not just these issues in silos. You think about it, it comes up with abortion, it comes up with other LGBTQ rights, it comes up in book bans where parents don't want their students reading things that go against their religious beliefs. Or with abortion, like they have religious exemptions if they do not want to, provide that care, they can deny providing that care all under the guise of a religious exemption. So I think that what we are seeing is the same playbook of attacks on things like marriage equality is rooted in similar rights, such as abortion, such as education. And states that are more protective of those things are more protective of education and healthcare. And a point that Kenya had made earlier about that there are definitely some states that still have on their state constitutions basically that marriage is still between one man and one woman. And although Obergefell is still in place, the idea was that if it were to fall, those trigger laws would have been put in place in states like Texas and Florida and Ohio um, that would have basically made it illegal again. And I think as we look at Ohio specifically, a potential ballot measure that we are tracking is this idea that they're trying to enshrine the right to marry into the Constitution. And so that is not a certified measure yet, but I think there are people behind that effort because they want to make sure to protect, their citizens if anything were to happen with Obergefell.
Thank you so much for that, Mira. And actually, thank you for bringing up the Scrimeti case in particular. Because one of the large focuses that we had at the task force was actually having to pay attention to the Scrimeti case and the opportunity to actually allow people to opt out from being able to receive more inclusive education curricula and access to books. And what we actually noted was obviously some of the framing around this is very clear that like it looks like we are just trying to villainize religious communities and their dissent towards that. But the fact of the matter is that there often also exists a pretty large coalition of faith communities that are pushing back against that kind of rhetoric. And it's used to speak up for all religious communities and all denominations. And particularly in the Scrimeti case, we noted that a coalition of folks representing Christian, UU, Jewish, and others, religious backgrounds, ended up actually putting in an amicus brief against the Scrimeti case. And it's oftentimes many coalitions of interfaith communities that show up on a progressive front to say, actually, we entirely disagree with the premise that their religious interpretation takes precedent over ours. And in an opportunity to talk about a freedom of choice, they constantly are pushing back against narratives that say that actually you are robbing the opportunity of choice because you have a narrow way of interpreting how religion should be showing up. So it's really important to be able to pay attention to some of those dynamics and how they actually get really started at the grassroots level. It's local faith communities that speak up and say that they are wanting to go against some of those notions that come up in these cases and often don't know where to start. And it takes organizations like the Interfaith Alliance, like some of our major faith-based organizational partners who actually start the conversations on amicus briefs and are looking for local faith communities to sign on because there are certain protections that you have where you can speak up towards certain things as long as you're talking about it at a 30,000-foot level and not trying to endorse specific candidates or laws that are trying to be passed, where your faith tradition, your value system can be a part of how you represent yourself and how you speak out against injustice. So it's really important to pay attention to some of those dynamics as they develop when cases end up going through the courts. Um, and with that, again, I invite folks whoever might have a question, please raise your hand, turn on your camera, ask the question in the comments that you would like. We're really wanting to make sure that you all have the opportunity to be in this conversation too. I think you all should have the opportunity to. Now you should be able to unmute yourselves.
Hi there. Um, this has been a wonderful presentation. Thank you so much for all of this information. My question is, are there any, I guess, just heavy hitters like Kim Davis out there that we're also looking at? Anyone similar to that, or anything that's on the radar, or we're just all kind of doing what we can to make sure that doesn't necessarily happen?
So nothing on my radar particularly, but there are cases that are coming up that are related to impacting other LGBTQ plus rights. So sports bans. So there's supposed to be oral arguments for West Virginia v. PBJ and Little v. Hecox in January of 2026. And although that has to do with sports ban, that still has that like domino effect of impacting other LGBTQ plus rights. And depending on what the Supreme Court decides, again, this is just oral arguments in January 2026, and they probably won't have a decision until their end of the term, which is in June. That can give rise for people to bring challenges against same-sex marriage and the confident to do so, depending on, again, the decision itself. And especially after the Supreme Court's last term with the Scrimetti decision, Mahmoud v. Taylor, I do think that gave certain people confidence, legislators, petitioners, to challenge groundbreaking cases. So as of now, I don't see anyone else like Kim Davis bringing challenges to Obergefell, but that doesn't mean that there won't be another Kim Davis, because I mean, they're out there. There are people out there that want to challenge Obergefell, and there are organizations that take on people to do impact litigation to challenge groundbreaking cases, similar to Edward Bloom. This is Students for Fair Admissions. This was a case dealing with affirmative action. There are people like him and organizations that have people like him that bring these challenges. So, short answer is no, but you never know.
Cool, thank you.
Mira, go ahead.
Yeah, I just wanted to second what Kenya was saying, that there isn't someone like Kim Davis and the kind of aura around her as bringing something against same-sex marriage, but I have seen in the last couple years different states legislators trying to bring measures to reverse the Obergefell decision. So states like Idaho, Montana, North Dakota, and South Dakota. I think Idaho's House had passed its resolution to overturn same-sex marriage. And obviously, Obergefell is the law of the land, but I will say that there are definitely lawmakers in states who are still behind reversing same-sex marriage.
I would second what Mira said and third what Kenya said. With the addition that it's important to keep in mind that the cycle of this work is going to be hard to keep up with because not everything happens the minute it hits our media. A lot of this preemptive work, a lot of this like preparatory work is constantly going on when it's not in the media cycle. And two particular organizations that, actually come to mind that help push back against this are Alliance Defending Freedom and Focus on the Family, who for decades have actually been trying to do this work at the national level and at the state level to push back against things like LGBTQ plus rights, particularly against same-sex marriage as well. So it's really important to consider that it's not the top folks that hit your screens, it's also about the organizations that back them up when it comes to fighting the cases and trying to actually come up with the ways to use the right language to scare people and to put them in place ready to do the work to push back. Any other questions from folks? You should be able to unmute or put your question in the chat if you'd like. Well, if there isn't any other questions, actually, oh yes. There's a question that I received. How do you all envision marriage equality and faith communities' attitudes towards congregants who identify themselves as belonging to the LGBTQIA plus community a decade or two from now? Also providing context that they said thank you to us three for having such a rich and educational program.
Wow. Mary, did you want to take this first and then?
I mean, I was gonna say that this is like a Tahil question is the first
Yeah.
thing because it's not faith community. So I'm gonna let Tahil do it. Kenya, if you have something, go ahead.
Okay, go ahead.
Cool. Yeah, I mean, you know, the imagination of marriage equality is actually really interesting because I guess in the context of much of what Kenya, Mira, and I discussed has still a lot to do with the Christian idea of marriage and the Christian rhetoric that pushes back so much against LGBTQIA plus people. So one of the things that I do imagine is that we are being way more mindful and intentional about this evolving idea that like the idea of consensual marriage between two loving adults is something that can occur across traditions, across identities, and across spaces where we don't think they're still possible. So we have a lot of work that we still need to do to be able to actually move from marriage equality to marriage equity. Because we tend to actually leave out a lot of points when it comes particularly to trans, non-binary, intersex individuals that are a major part of the long nomer of different identities who often aren't in this conversation because they unfortunately either get ignored or their cases end up being so much more complex and are riddled with more rhetoric and vitriol that it actually makes it harder for them to even be a part of the marriage equality conversation. So what I do actually imagine is that faith communities actually grow a larger understanding that is built on better understandings of all of the different letters of the LGBTQIA plus community, what their needs might be, and more importantly, the interfaith literacy that it actually needs to complement. I imagine a time where faith communities are actually coming together to strategize and think more effectively about how do you support your local LGBTQIA plus people, and it's not a one-off project or program by one specific church or synagogue. That it actually becomes an interfaith effort where people are bringing their resources together to actually really make spaces that are safe, secure, and sustaining. I think it takes a lot of work to be able to do that. And, with the direction of the attitudes, it seems like we're already sort of setting ourselves up for the first steps of success in doing that. And I think it's a matter of really reimagining how we're engaging the conversations accordingly. Kenya, Mira, do you want to add to that?
I think that was eloquently put. I agree with what you said wholeheartedly. And I love the point about you saying, like, you know, there's a difference between equality and equity. A lot of times people use those words interchangeably. But equality for me specifically is like just the floor, the ceiling is always going to be equity and inclusivity. And I think that we do leave a lot of people out of the conversation of same sex marriage, a lot of communities that are within the LGBTQ plus community. But, you know, I think the first thing that people think of is like still like this, you know, cisgender white union, despite it being same sex. So trans, non-binary, other marginalized members of the LGBTQ plus community.
Absolutely, Kenya. I really appreciate that perspective. I think it's exactly that. Marriage is not just the ceremony, it's not just the reception that you do after, it's not just the honeymoon. It's actually so many legal and social precedents that you're setting that if you don't tend to see yourself in the participation, you tend to then think that it's not something you're allowed to do or it's not something that is for you. And the fact of the matter is that if you want to make the choice to be married, you should have the choice to be married however you see fit. And that's an experience for BIPOC people, that's an experience for people of cross-faith traditions, and it's an experience that many LGBTQIA plus people want. And to be able to live in a country where there's supposed to be equal access and opportunity under the law, that should be one of those things that we continue to fight for as a part of it, for the ripple effect that it also causes in enshrining the rights of LGBTQIA individuals in so many other ways. So thank you for that. I'll give one more chance for anyone to ask questions, but if not, I will just like to say thank you again, Kenya, for your time today, for giving us this presentation, for educating us about the context and the way forward, and being able to engage in this. And of course, I also want to thank Becca G, Mira, and the Interfaith Center at Miami University, as well as the National LGBTQ Task Force. And especially everyone here that's in the audience who wanted to listen in and learn, because this is where we can really take the work. The work now is about making sure that you all have this information, are able to share it with others, and that it inspires and motivates you to do the good work. Because boy, do we need all sorts of activists everywhere, whether it's in Oxford, Ohio, or whether it's in Washington, D.C. So keep on keeping on. Thank you all so much, and hope you have a wonderful day.
Thank you so much. See you.
Thank you. Thank you, Tile.
Thanks.